health and legal system, and the law failing to protect me. Judges that were completely biased and had conflicts of interest decided the assisted dying cases. They were supposed to be fair and impartial, but instead let down our country and failed to protect our most vulnerable. What is happening to vulnerable persons in Canada is so wrong. Assisted dying is easier to access than safe and appropriate disability supports to live. Committee members, you cannot let this happen to me and others. You have turned your back on disabled and elderly Canadians. You or your family and friends will all be in my shoes one day. You cannot let this sliding regime continue. The Truchon decision is an illegitimate decision made by a biased and compromised judge. Christine Baldwin made her decision because her father's works were used as evidence by the plaintiff's lawyer. She should have recused herself and declared her conflicts of interest. The same issues of bias, conflict of interest, and misleading Canadians about assisted dying happened in Carter, during the Lamb case, and with the Audrey Parker situation. The grave mistakes by our legal and healthcare system and the failure to protect our most vulnerable needs to end. I read an email from Jacques Truchon prior to his death revealing all he needed was 70 hours of home care per week to live. Instead, he was wrongfully assisted to die by our health and legal system. I made complaints to the United Nations and his special rapporteur completed a country visit. Her report was very critical, where she is extremely concerned about persons with disabilities being asked to consider assisted dying. I made a complaint about the lack of independence and impartiality of our courts related to assisted dying to the special rapporteur on the independence of judges. I also plan to assist with the motion to retract Truchon in Quebec, as I do not believe the judgment is legitimate and puts all persons with disabilities in grave danger. You are all highly intelligent individuals dedicated to public service. You're not so gullible, are you? Are you persuaded by propaganda, misinformation, and a lack of objectivity by decision makers? Your constituents expect you to scrutinize what has actually happened with the sliding practices of assisted dying and what you need to do to protect all citizens. Please move away from the dogma and see things how they really are. Do you want to help vulnerable people who want to give back to society and be a part of our community, like heroes such as Terry Fox? Or do you just want to be misled and have blood on your hands? My blood will be on your hands if you allow the illegitimate Truchon decision to tear down our laws. I will not survive, and there will be thousands of wrongful deaths. Help Canada be the country it should be and not what it is currently sliding towards. Thank you for your time.
Thank you very much for that, Mr. Foley. We will now move on to the Association of Reformed Political Action Canada. You have 5 minutes. Please go ahead.
Thank you. I'm glad I could be here. Just a few days ago, my wife gave birth to our daughter. And during her pretty long labor, doctors presented her with different options. It's of course new to me, but meso or oxytocin to move things along. They needed to move things along faster. Epidural, forceps, or vacuum, or C-section was discussed at one point. So in our vulnerable state, we trusted that the options the doctors presented were good options. We also wanted to know what the doctor thought was the best option, and frankly, we went with it every time. Now, medical assistance in dying, or assisted suicide, or consensual homicide, or whatever you want to call it, is not healthcare. At least it's fundamentally distinct from any other medical service. Advising someone to have a C-section or chemotherapy or pain medication is not a crime, but encouraging or inducing someone to end their own life is a crime. If M.A.I.D were simply another healthcare service, we wouldn't be here today discussing substantive amendments to the criminal code. Medical services are not regulated by the criminal code. We are wrestling here with when we as a society will permit some people to kill others. That's why this is before Parliament. The fundamental problem with this bill, as we see it, is that it fails to take this seriously enough. It's almost flippant in its treatment of the deliberate termination.
Excuse me, Mr. Chairman. The interpreters are unable to interpret because Mr. Sikema is speaking too quickly and they do not have the text. It seems that you don't have this information. Apologies to Mr. Sikema, but I believe that we should be able to hear correctly.
Mr. Sikema, if you can please slow down a little bit in your remarks. I've stopped the time so that you don't get penalized for this. But if you could also move your microphone just a little bit above, like between your nose and your mouth, so that we don't hear that popping sound as well. You want to give it a go? Thank you. Go ahead.
Apologies to the translators. I meant to flip this to them a little while ago. Our current law, as amended by Bill C-14, is already interpreted to allow doctors to euthanize patients who have a decade or more of life ahead. Our current law already fails to prevent doctors from suggesting M.A.I.D without being asked, at least listing it as an option, which can send a powerful message to the sick and disabled that someone thinks their life isn't worth living. Bill C-7 not only fails to address those problems, as identified by the United Nations Special Rapporteur, among others, but it makes them worse. If Bill C-7 passes, it will be possible for a person with a serious illness to go to their doctor's office, have their doctor suggest M.A.I.D as an option for them, have the doctor's secretary pop in to witness a written request, and then to be killed as soon as a second opinion is acquired. Of course, the doctor would have to mention other options, but that's just a basic rule of informed consent. Now, that's the fast and easy track. The slow track isn't much better. For those in the ambiguous category of not reasonably foreseeable death, Bill C-7 says that other options should be discussed and consultations offered, which isn't much, and one would think that such basic steps should already be there for the fast track cases. As for the 90-day waiting period, the palliative care physicians have already pointed out that it's inadequate because it often takes longer to help people manage their symptoms and to find satisfactory treatments and so on. We share that concern, but we also would point out that the 90-day waiting period is itself ambiguous, given that it begins not on the day a written request is signed and dated, as with the 10-day waiting period that would be cut, but on the day the doctor begins to assess a patient's eligibility, which could be months earlier. Now, many people seem to think further expansion of euthanasia is inevitable. This is not true. The Carter decision was very limited in scope, as the court stated at the beginning and end of its decision. This is about Ms. Taylor and persons in her position. She was near death with a known fatal illness. And the court said, we make no pronouncement on other situations where physician-assisted dying may be sought. At the end of its judgment, it bookended its judgment with those things. The lone judge who decided Truchamp failed to appreciate this and failed to recognize Parliament's objectives in limiting M.A.I.D to the end-of-life context. Now, it is the responsibility of Parliament and this committee to listen to the concerns of all parties, including disability rights advocates, palliative care physicians, and others, to be clear about its objectives, to defend them against a particular judge, and to enact more responsible policies. Thank you very much.
Thank you very much for that, Mr. Sikema. And if you can please send us your written submissions as well, or your speaking notes, it would be helpful for members. Thank you for that. We'll now move on to Inclusion Canada. That is Ms. Carr, who is the Executive Vice President. Please go ahead, Ms. Carr. You have 5 minutes.
Good morning. I'm Krista Carr, Executive Vice President of Inclusion Canada, formerly the Canadian Association for Community Living, Canada's national organization for people with intellectual disabilities and their families. Inclusion Canada has advocated for safeguards in M.A.I.D since we intervened in the Carter case. Our biggest fear has always been that having a disability would become an acceptable reason for state-provided suicide. Bill C-7 is our worst nightmare. Inclusion Canada stands united with all national disabled persons organizations in calling for M.A.I.D to be restricted to the end of life. The disability community is appalled that Bill C-7 would allow people with a disability to have their lives ended when they are suffering but not dying. This is not how we respond to the suffering of any other group of Canadians, much less any other charter-protected group. We're told this abrupt pace of passage through Parliament has been set by the Quebec Superior Court, yet amending the criminal code to satisfy a Superior Court decision appears unprecedented. We're told Canadians want this, yet every national disability organization is opposed. If Canadians supported assisted suicide for being Indigenous or a member of the LGBTQ2S+ citizens, for example, who are suffering as a result of being Indigenous or because of their gender identity, we would not be here today. Canadians recognize suicide is more prevalent amongst those who experience systemic racism or societal devaluation. Thus, prevention is a necessity, and every life lost is a tragedy. Why is it not just as great a tragedy for an Indigenous person with a disability or someone with any other identity who has a disability? And I hope you will hear from Indigenous organizations as part of this committee. The human rights of a charter-protected group must never be a matter of public opinion. Equating assisted suicide to an equality right is a moral affront. There are 3 points I'd like to cover. First, why us? As no other charter-protected Canadian life is being put at risk by this bill, there is only one answer to this question. The lives of Canadians with disabilities are not of equal value. Language and perceptions are powerful. Including disability as a condition warranting assisted suicide equates to declaring some lives as not worth living, a historically horrific premise with consequences that should terrify us all and clearly terrifies the disability community and their families. Second, people with an intellectual disability and their families are in a constant struggle for inclusion, a universal human right not yet realized in Canada. When people with intellectual disabilities suffer because of their pervasive exclusion and marginalization, families now fear their family members will be encouraged to end their lives. Rather than address their suffering as we do for every other Canadian who tries to end their suffering through suicide, their lives are now judged as not worth saving. To be clear, an inclusive life remains elusive for the majority of adults with intellectual disabilities. There is no right to adequate supports in Canada. 75% of adults with an intellectual disability are unemployed. They are 4 times more likely to be living in poverty, 4 times more likely to experience violence. And a staggering amount of people with an intellectual disability remain housed in institutions and long-term care facilities. Canada is failing its commitments under the UN CRPD to uphold the rights and inherent dignity of all people with disabilities. Persons with disabilities in Canada suffer an inadequate patchwork of supports with extensive wait lists for services. A state-sanctioned death is not the solution. Third and lastly, until now, M.A.I.D has been restricted to end of life. The end of life requirement was the only safeguard whereby disability was not the sole criterion. With having a disability itself under Bill C-7 as the justification for the termination of life, the very essence of the Charter of Rights and Freedoms would be shattered. Discrimination on the basis of disability would once again be entrenched in Canadian law. People with disabilities have been historically devalued and marginalized in Canada, and that remains to be sufficiently remedied. Bill C-7 further devalues the lives of people with disabilities and fundamentally changes M.A.I.D from physician-assisted dying near the end of life to physician-assisted suicide on the basis of disabilities. The lives of people with disabilities are as necessary to the integrity of the human family as any other dimension of humanity, and this threat to the lives of people with disabilities is a threat to us all. We urge the committee to seek an amendment to M.A.I.D to sustain M.A.I.D as available only to those who are dying and unequivocally restrict anyone with a disability from having their life ended unless their natural death is imminent. Thank you.
Thanks very much for that, Ms. Carr. And thank you to the witnesses. We'll now move on to our first round of questions. So the first round of questions will be 6 minutes each. Mr. Moore, please go ahead. You have 6 minutes. Your time is starting now.
Thank you, Madam Chair, and thank you to all of our witnesses. You all bring something different to this discussion, and really appreciate your very informed presentation. And, it concerns me when we're dealing with something that's literally life or death. The dramatically reduced time that we're dealing with this important issue. We're only taking 4 days of meetings to discuss this. Parties are only going to have about one round of questions to ask you important questions. And when I hear Inclusion Canada, an organization that works with those in the persons with disabilities community from coast to coast, describe this as a worst nightmare. I really truly believe that we need to have more discussion on this. The government would have us believe that this is a open and shut case, that there's a great deal of unanimity amongst doctors. But I'm going to ask my first question to Krista Carr with Inclusion Canada. There's a group called Physicians Together for Vulnerable Persons. We received a letter from them, and I know your organization works deeply with vulnerable persons. It was signed by 800 medical doctors throughout our country from every province. These are people that are working with people who are vulnerable. And I know the position of Inclusion Canada was that the Court of Appeal decision should have been appealed even to the Supreme Court. That happens to be the position as well of the Conservative Party, that this decision should have been appealed. But this bill goes far beyond even responding to the Quebec decision. And my question to you, if you can answer it quickly, is are you, as Inclusion Canada, of the opinion that this bill needs more review to analyze the impacts, even that we heard about today, on safeguards for the persons with disabilities community?
Thanks, MP Moore. Yes, we are, of course, of that opinion, and we also we feel very strongly that the only way to make this bill not discriminatory is to keep it to the end of life. Anybody who is at end of life and is suffering intolerably has access. When you make it based on the grounds, open it up and make it based on the grounds of things like disability, who is already a very vulnerable population in our society today and experiences a tremendous amount of systemic ableism in the healthcare system already. And we've seen that pervasively throughout the COVID-19 pandemic in everything from triage protocols, deprioritizing their lives, and the list goes on. We're in a very dangerous slippery slope. And I think we have to stop, hit the pause button, and really, really focus particularly on a consultation with the disability community. We are speaking, we are trying to speak, we are united, but our voices are getting drowned out by people who do not experience the systemic marginalization, the poverty, and the very difficult lack of supports and life circumstances that people with disabilities experience that lead them into situations where MA-ID is either promoted to them or they feel like it's their only option. But
Thank you. Thank you for that. That brings me to my next question. The promotion or the choice that people are being dealt. Mr. Foley, thank you so much for your testimony today. You certainly bring a perspective that we have not heard at this committee. I think we should hear more of your perspective with the government expanding access to assisted dying in Canada. I heard the recordings that you had where a doctor was pressuring you into M.A.I.D and was saying that the per diem rate to stay at the hospital was $1,500 or so dollars. And you mentioned the contributions of persons with disability, including Terry Fox, and how much even that you're doing today by bringing this, standing up for vulnerable people at this committee for this meeting. My question to you is, do you feel there should be greater protections in this legislation that we have before us for vulnerable Canadians so they're not pushed, as you were, towards medically assisted death?
Mr. Moore, I'm going to answer that on behalf of Mr. Foley. Absolutely, there needs to be very robust protections here because people with disability can be easily exploited. They're subject to abuse, and they could be at high risk of being wrongfully assisted to die. The other issue is that such individuals, the disabled, all they really need is the care and support and good care. And 99.9% of the time, their grievous and irremediable suffering will be gone. You do that, you solve the problem. Then for the remaining 0.1%, where you can't relieve the suffering, then let's take a look at this. This is a subjective conclusion based on the individual.
Thank you.
There is a
Thank
there
you,
is
Mr. Berger. My apologies. We're out of time for Mr. Moore. We're going to move on to Mr. Virani for 6 minutes. Go ahead,
Thank
Mr.
you.
Virani. Your time starts now.
Thank you very much, and thank you to all of the witnesses for their important testimony today. I wanted to start with Ms. Campbell. Ms. Campbell, we've heard today and we've heard in previous testimony about instances of influence, potential coercion. You yourself are a nurse in the middle of this milieu. Can you tell me, is the appropriate step when such instances are raised to raise a complaint to both professional regulatory bodies and or the police if such influence is being asserted so that it can be investigated? And if that is the proper course, can you tell me what is your knowledge of any complaints resulting in actual prosecutions against nurses or physicians, if you're able to answer that? Thank you.
Sure, thank you for the question. The answer is no, there hasn't been any that I'm aware of move forward. And certainly there are those safeguards and steps in place for patients or families to raise those concerns. So that exists. And I believe there's a very big difference in our language between saying that something is available and saying that someone then warrants or needs or should have a certain procedure just because it's available. That's very individual. And the same thing, to advise of alternatives is not the same as encouraging. So I think they're very different in how we word those.
And in your experience, Ms. Campbell, is active encouragement and pressure being put upon individuals to pursue medical assistance in dying?
No, in fact, what I find is more people that come and say, I wish I knew that those were my options earlier. Nobody mentioned it to me. So I think as important as it is to, I think it's very important not to encourage anyone to pursue a particular option, but it's equally important that all patients know all of their options and get to decide for themselves which option is right for them.
If I could turn to Ms. Carr. Ms. Carr, I respect the work that you do and all of the groups that you represent in your interventions in previous court cases, et cetera. I'm just struck by something that when I look back at the Truchon decision, the two individuals in that case, Mr. Truchon and Madame Gladue, were themselves persons with disabilities. They themselves brought forward the claims that they put in front of that judge in the Quebec Superior Court. What the judge found, and I looked back at it while you were testifying, and I was reading from about paragraph 681 and following all the way to paragraph 690. It's a long decision. But the judge addressed head on the issue that you're raising, and you raised the equality rights of these individuals, and you compared sort of indigeneity or people who experience racism, et cetera, with persons with disability. Those are important rights. This is an area that I practiced in prior to coming to Parliament. But what the court found is that when you look at it from an equality rights analysis, in fact, the Section 7 and the Section 15 rights of Monsieur Truchon and Madame Gladue were being violated by virtue of their inability to pursue M.A.I.D because it was restricted to the end of life. So they did do that analysis, but the conclusions are vastly different than what you indicated in your testimony. So I'm just wondering if you could comment to us on that portion of her decision, because what she clearly said is that by seeking to counter only one of the stereotypes, I'm reading from paragraph 681, by seeking to counter only one of the stereotypes that the disabled face, vulnerability, the challenge provision perhaps perpetuates another probably more pernicious stereotype, the inability to consent fully to medical assistance in dying. And what she explained is that we need to empower and give autonomy to persons with disability, the same autonomy that is granted to people without a disability. So I've lost you on my screen. I'm sorry, there you are. If you could perhaps comment on that point, Ms. Carr. Thank you.
Yes, thank you for the question. First of all, I want to point out that Jean Trouchon was presenting himself for a medically assisted death because he couldn't get a good life. And that was very clear in the proceedings. He was forced to live in an institution. He didn't want to live there. His life was not good. He tried, there were multiple attempts for him to live other places and have a better life. And nobody seemed to be able to get him out of that place. And that's how he ended up there in the first place. And that's the thing we lose quite a bit when we talk about the Trouchon decision. The second thing is about the rights piece. So we talk about this being all about autonomy. It's all about individual choice and decision. But it is a balance of autonomy rights and equality rights. And Section 1 of the Charter, that's what we have it for. We say that we can violate autonomy rights if it's for the public good. And we have to keep in mind that for people with a disability, this is not a choice. Every day of their life, the lives that they are forced to live because of inadequate supports, poverty, and society depriving them of inclusion causes their suffering. And that suffering can be remedied through many, many, many other means. But because we don't respond and governments don't provide the supports and communities and society don't include people, then they're forced into situations where they feel they have no choice. Sure, they're presented with options. For example, the bill says we need to let people know what services are available. But letting people know what's available doesn't get them services and supports, doesn't get them off wait lists, doesn't get them out of institutions. It doesn't make their life better. Until we're committed to making sure that everybody has the opportunity, an equal opportunity to live a good life, then medically assisted death on the basis of disability is not the solution.
Thank you very much. Thank you, Mr. Virani. Monsieur Thériault, voulez-vous commencer pour votre...
Would you like to comment? You have 6 minutes. Yes, I'd like to thank all of the witnesses for their testimony this morning. Mr. Foley, your testimony was both touching and troubling. In the debate such as the one before us, we must absolutely not confuse concepts. The reasonably foreseeable death criterion, as far as practitioners are concerned, was something that was causing problems. In Quebec since 2015, terminal end-of-life care, in other words, a palliative situation, could lead to the emergence of a patient's asking for medical assistance in dying. Palliative care, which should still be improved, it's one thing to demand better conditions for patients. It's something entirely different to substitute oneself for their own freedom of choice. We must not be paternalistic. And an individual's dignity is based not on physical dignity, not on psychological autonomy. That's not cognitive capacity. Those promote autonomy. But a person's dignity is based on the respect of their moral independence, and their moral autonomy is based on having their free choice respected, their ability to determine for themselves in a biomedical situation. This means free and informed consent. Mr. Foley was not in a free and informed consent situation, and he is before the courts. I'm going to stop there. I don't want to comment on that situation. But that's not what things are about this morning. This morning, the issue is to be able to enable individuals who are in an irreversible dying process, because it's already underway in a terminal situation, to have a choice. In the case of others, such as Mrs. Gladue, who has not yet exercised her right to die with dignity, was saying in an interview that she was already relieved and she was suffering a little bit less because now she had the choice that had been removed from her. So we must not confuse a suicidal state or the societal combat against suicide, because that's irreversible, and a point at which a human being who has experienced a full and complete life, such as a case of, for example, what Mr. Foley was talking about, he's demonstrated that he has had a full and complete life. Now he's more limited somewhat. It is up to the human being, up to the patient, only the patient. The patient is the norm. It's up to the patient to decide. Mrs. Carr, you are against this principle?
We're against the systemic discrimination of allowing people to be euthanized or put to death because on the basis of their disability, when they can't get the support they need to live well within their communities. And so they may very well find themselves in the system, in the medical system, and by virtue, and the suffering that they're experiencing is being caused by the lives that they are living. And they can't get the support they need to live the lives that they want to live. And the medical system alone cannot get those supports for them. So having access to ending your life, as opposed to being able to live a good life. I mean, if somebody is already dying, and we already have that in the legislation, if somebody is already suffering intolerably and their death is reasonably foreseeable, they can access M.A.I.D anyway. Anyone can do that. What we're doing with Track 2 or Bill C7 is we're singling out one particular charter protected group of Canadians and saying, boy, it must be terrible to live your life. And we think it's so terrible that we're going to assist you to end it when you show up in the system and you need support to live. And I know we're not necessarily doing it intentionally, but that is what happens. And we have examples that I'm happy to send of case after case after case of this very exact same
Madame
thing.
Carr, excusez-moi.
Mrs. Carr, maybe it is not up to me or to you, or only the patient, itself or herself, should define what is tolerable for that person. That is respecting the person, their dignity. Of course, we want to have people to have the best care possible, but in the end, you will agree with me that only the patient can decide what is tolerable or not, and to have freedom of choice.
20 seconds, Ms. Carr.
Having respect for people is trying to make their lives tolerable and bearable the same way we do for any other person who is not identified as having a disability who tries to commit suicide or wants to end their life. We intervene in every possible way we can to help make their lives better.
Thank you, Ms. Carr. Merci, Monsieur Thériault.
Thank you, Mr. Thériault.
Mr. Garrison, you have 6 minutes. Please go ahead.
Thank you very much, Madam Chair. And I want to thank all the witnesses who appeared before committee today, and also to thank members of the disability community and their advocates for their passionate presentations both today and away from this committee table. I guess I would say that I do believe we need to hear more on these issues, and that's why I, as I've said before, am disappointed we have not yet started the statutory review of medical assistance in dying, which I believe deals with some of these larger issues that are being raised today. The court decision took reasonable foreseeability off the table, whether we like that or not, and whether it had been appealed or not, I believe it would be likely to be upheld in higher courts. So what we're left with is an attempt to deal with that decision and to deal with some other urgent issues in medical assistance in dying. So I want to turn back to Ms. Campbell, who raised those issues, which I've heard a lot about in my constituency. And that's the issues of relieving suffering caused by the 10-day waiting period and also by the inability to waive final consent. And I believe those are urgent things we must deal with that justify a speedy consideration of C7. So could you say a few more words about those issues, Ms. Campbell?
Thank you for the question. Patients that call me are not calling me at the first thought that they've ever considered medical assistance in dying. These are people who have really considered, they've often been in the healthcare system for a long time, they've been presented with many options, and they are knowledgeable people who have evaluated their own values, their own experiences. Many of them have discussed this thoroughly with their family before they've called, and they're not jumping at making that phone call, but they are making the call to determine what other options may be available to them so that they can best consider those. So I think they're frustrated with then having to wait another 10 days once they've come to that decision. And advanced consent is the one that I actually hear the most about. And I hear that more from patients who are really at risk of losing their capacity, such as the Audrey Parker case. Or I also hear it from many community groups who are really concerned that should they be in that position in the future, that those rights would not be available to them.
Thank you. In testimony from Dr. Dawes, who's also a M.A.I.D. assessor and provider, she said to the committee and also in a written brief that she didn't meet anyone who wanted to commit suicide. She didn't meet anyone who wanted to die. She met people who wanted to deal with what nature was presenting them in a dignified manner. Can you comment on your experience with this?
Yeah, I would say my experiences are very similar. If I could give my patients anything, I would give them life. But life isn't necessarily the options that they're being presented with. So when they look at their different options, they're considering M.A.I.D as one of those options. But many of them are choosing between very hard choices. And my wish for them to be better certainly doesn't make that so, although I would do everything I could to assist with that.
And I know time is very short, but can you give us a brief comment on the role of witnesses, since we sometimes seem to assume that witnesses are judging whether the assessment has been correct, when in fact they're judging what the identity and the signatures on documents, I believe. Can you tell me if I'm correct in that?
You are. The witnesses generally are, they are sometimes independent volunteers with no medical contact whatsoever, just simply noting that that person signed that form or that person directed a third person to sign on their behalf when they're not able.
Thank you very much, Madam Chair. In the interest of time, I'll conclude my question there.
Thank you very much for that, Mr. Garrison. You still had a minute and a half, but that is okay. So in that case, we'll move on to our second round of questions with 5 minutes, starting with Mr. Cooper. Go ahead, Mr. Cooper.
Great. Thank you very much, Madam Chair, and thank you to the witnesses for your very helpful testimony. I want to direct my first question to Mr. Sycamore, Mr. Schutten, as well as Mr. Berger. In the Supreme Court Carter decision, the court adopted the pronouncement of the trial judge, wherein the trial judge stated that risks associated with physician-assisted death, quote, can be identified and very substantially minimized through a carefully designed system that imposes strict limits. Now, we have heard some fairly compelling testimony about how vulnerable persons could be put at risk as a result of the removal of important safeguards passed in Bill C-14. Can you speak to any charter issues that you see in that context, Mr. Sycamore, Mr. Schutten, or Mr. Berger?
Perhaps I could respond to that very intuitive question. The Charter also involves the right to life and security of the person, which seems to have been forgotten, and clearly the trial judge in the Truchon case, in my opinion, did not pay sufficient attention to that. The fact is that there, as you mentioned, there needs to be strict limits. Well, the problem is, as I was mentioning earlier, this is a subjective decision based on potential influence and based on coercion. All we have here is government questionnaires with leading questions. And with respect to anyone who's making a decision, the M.A.I.D assessors, there's the risk of confirmatory bias. So if they believe that assisted dying is right, they are more likely to not see issues with capacity, not see issues with the consent, not see coercion, because what they think that they're doing is something humane and right. So there needs to be robust, strict protections here, including not only substantive protections of only doing it near life, but having committees decide this, not a physician who's actually doing the act, because they're more likely to find that what they're actually doing is correct. So there needs to be substantive safeguards and procedural safeguards that are strict and rigid. Thank you.
Thank you for that. Mr. Sikkema, I'll give you a chance to weigh in on my question as well.
Thank you. Adding to what Mr. Berger said, I think the expert report of Dr. Madeline Lee in the Lamb case is quite instructive on this. She actually developed and she oversees the M.A.I.D program at the University Health Network in Toronto. And in her expert report, she describes the case of a woman who had bone cancer and depression. She was assessed by two experienced M.A.I.D providers, not by her oncologist and a psychiatrist, and they approved her for M.A.I.D. She changed her mind during the 10-day waiting period and decided to do palliative care instead. Later, during another crisis, she requests M.A.I.D again, and her M.A.I.D providers decided that again that she's eligible, go ahead. They apparently had no concerns about her ambivalence. And then she ended up changing her mind again during the next waiting period. We talked about the waiting period not mattering as a protection. I mean, this is right there in an expert report by someone who designed the system in Toronto. It's quite remarkable. I recommend looking at that expert report.
And any comments on charter issues specifically?
Yeah,
go ahead. Yeah.
My colleague Andre's on the call. He's written a paper about just how practically this means the criminal law does not protect your life as strongly. I'm speaking for him here, but as strongly where you have a disability or a chronic illness, because your death wouldn't be investigated to the same extent. We talked about equality earlier on this call. I can't get M.A.I.D because I'm not disabled. So the disability equality angle has kind of two sides there, and I think that's important to recognize. That Section 15, I think, goes the other way too.
Okay, Mr. Berger.
Mr. Cooper, you literally have 5 seconds. Sorry about that,
okay,
Mr. Cooper.
No problem. Thank you, Madam Chair.
Thank you. We'll move on now to Mr. Zaberi for however much time it takes us till we have to get through this panel. Thank you. Go ahead, Mr. Zaberi.
I want to thank all the witnesses for joining us today. I wanted to put this question to Mr. Foley and others who want to contribute to this, but essentially, I know that many of you are advocating against opening up M.A.I.D to non-reasonably foreseeable deaths. I appreciate that. It's something we're considering. However, let's say I want you to open up and let's say for a moment that we actually do consider non-reasonably foreseeable deaths. In your opinion, how do we protect those with disabilities from your vantage point and vulnerable persons? Mr. Foley and others who would like to contribute.
Madam Chair, I don't believe it's possible to protect the disabled if you open it up. It's already there's already cases with the existing law demonstrating that the disability community is in danger, and this is just further going to exacerbate that. So there is no way of, in my respectful submission, there is no way without limiting it to close to death. There is no way of limiting it.
Thank you. So just very quickly, I have another minute. Would anybody want to actually flesh out how we could, if we open it up, how could we protect disabled persons? I feel this is really important given what we're studying.
The current safeguards are already failing under Bill C-14. Taking away those safeguards, there's absolutely no way to protect vulnerable and disabled persons from a wrongful assisted death. I'm disabled, and I know that if you pass Bill C-7, I won't survive, and there'll be thousands of wrongful deaths, and you'll see the numbers pile up. So I urge you to please do not allow this regime to continue to slide.
Thank you. Thank you very much, Mr. Zaberi. We are a little bit out of time. My understanding is that there was a little bit of interpretation that was interrupted, Mr. Zaberi's. But I think it has resumed. If anybody has any issues with respect to that interpretation, please do reach out to the clerk. We'll get you that text. But I'd like to take this moment now to thank all of the witnesses who appeared today for your testimony. Thank you very much. We will be now suspending to move on to our second panel. Thank you again for being here today. welcome you to our second panel. Just a quick go over of the rules before we start. You can speak in your official language. Just ensure that you have the proper interpretation language selected at the bottom of the screen. When you're speaking, please speak slowly and clearly. And when you're not speaking, your microphone should be on mute. With respect to the speaking list, Mr. Clerk and I will do our best to ensure that we're maintaining that speakers list. I have a 1-minute card and a 30-second card that will allow us to keep time for the questioning. And at this time, then I'd like to welcome our witnesses. We have appearing before us today as an individual, Dr. Catherine Frazee, Dr. Ewan Golliger, and then we have the Organization of Council of Canadians with Disabilities. Appearing on their behalf is Dr. Heidi Jans and Taylor Hyatt. And then we also have Living with Dignity, and appearing for them is Michelle Rakiko. And I understand that Ewan Gollinger, who was having difficulties getting in, is now in the virtual room. So welcome. Excited to have all of you. I understand that some of the witnesses have audio recordings, so we'll go ahead and start and try to provide as much as possible. Dr. Catherine Frazee, please go ahead. You're our first opening witness. You have 5 minutes. Please go ahead.
I speak today from Mi'kmaq, the ancestral and unceded territory of the Mi'kmaq people. I am a settler here, bound by treaties of peace and friendship, and mindful that we are, all of us, treaty people. Madam Chair, I am sorry for any discomfort that my words may trigger, but with so little time, I must speak frankly and without reserve. Bill C-7 begs the question, why us? Why only us? Why only people whose bodies are altered or painful or in decline? Why not everyone who lives outside the margins of a decent life? Everyone who resorts to an overdose, a high bridge, a shotgun carried out into the woods? Why not everyone who decides that their quality of life is in the ditch? Surely the answer rises up in all of our throats. That's not who we are. We dial 911. We pull you back from the ledge, and yes, we restrain you in your moment of crisis. Autonomy be damned. We will get to the heart of the problem that drove you out into the woods, and we will beckon you back toward a life that is bearable. Unless your suffering is medical or disability related, then and only then there will be a special pathway to assisted death. Universality is the bedrock of our healthcare commitments. Why then does Bill C-7 depart so radically, dropping the threshold for M.A.I.D for one social group known to bear the trauma of suicide at catastrophic rates, but not for others who suffer and die before their time? What is it about disability that makes this okay? Why such breathless confidence that Bill C-7 will bring no harm to disability communities? Honestly, I do not know. But as we marshal our evidence for the legal challenges that will follow if this bill is passed, this is what we hear in reply. Some say that the suffering of a disabling medical condition is unlike other suffering, somehow more cruel than the overwhelming pain of any healthy, non-disabled person who turns to premature death by suicide. But there is no evidence to support this. Some say that the suffering of disability defies all hope as it did, they claim, for Jean Toussaint. But the deprivations of institutional life that choked out his will to live were not an inevitable consequence of disability. Did we learn nothing from Archie Rowland's harrowing struggle and his final cri de coeur before assisted death? It's not the ALS that's killing me, he said. Some say that the suffering of disabling conditions falls in the domain of medicine, but the agonizing quest of Sean Taggart teaches us otherwise. Let's not forget he called the bureaucratic denials of needed care a death sentence, just days before his assisted death. Some will fall back on the mantra of choice. They say that not everyone wants to live that way. But not everyone wants to live with the indignities of poverty either. No one wants to live under threat of racial or gendered or colonial violence. No one wants to live hungry, incarcerated, abject, or alone. Madam Chair, will our lawmakers carve out other shortcuts to assisted death for those who do live in such conditions? Or will you rise to the defense of human rights? If the latter, I respectfully urge that you start with us, for our equality is right now on the line. Thank you.
Thank you very much, Dr. Frazee, for your testimony. We'll now go on to Dr. Edwin Golliger. Please go ahead.
Madam Chair, honorable members of the committee, I speak to you as an academic physician scientist, a critical care specialist who frequently provides end-of-life care, the father of a child with physical disabilities, and as a very concerned Canadian citizen. I wish to address you specifically on the ethics of moral objection to euthanasia. The first patient I was ever asked to examine in medical school was a young man with profound disability from primary progressive multiple sclerosis. I will call him Nathan, though this is not his real name. Nathan was paralyzed from the neck down, bedbound, and blind. As I interviewed him, he began to speak of his experience as a person living with serious disability. He spoke especially of the deep loneliness that he felt, the isolation from the rest of the world, the absence of meaningful friendship. His pain was primarily not that of physical suffering, but of deep despair of ever enjoying meaningful human contact or relational intimacy. All these years later, I wonder if Nathan would have considered seeking a doctor's help to commit suicide. I invite each of you to imagine that you are the one to fulfill that wish for someone like him. You place the intravenous line. You inject the sedation to put him to sleep. You inject the paralytic agent to halt his breathing. Within minutes, his heart stops and he is gone. His loneliness and hopelessness are ended, and so is he. We must all agree that this patient's loneliness and despair are tragic. We all agree that he deserves the very highest level of care and compassion, that we must work to uphold his dignity and his quality of life. Yet with respect to the ethics of causing his death, many like myself find a variety of important reasons to object to participating in such an act. First, we argue that euthanasia devalues the patient by treating them as a means to an end. In order to make Nathan's suffering go away, we would make him go away. We intentionally target and end his person in order to resolve his loneliness and despair. In doing so, we are treating him, his person, as a means to an end, rather than as an end in himself. True respect for the intrinsic and incalculable worth of persons requires that they always be treated as ends in themselves. We do not destroy that which we regard as profoundly and intrinsically valuable. Second, since respect for persons is the moral foundation of the duty to respect autonomy, in treating persons as means to ends, we undermine the very basis for respecting their autonomy. If persons can be intentionally rendered non-persons, then what makes their autonomy inviolable? Third, in participating in the patient's act of suicide and causing his death, we are implicitly declaring that we agree that his life is not worth living. We are affirming his perception that his existence is no longer desirable, that we are supportive of his non-existence. Nathan's loneliness and despair highlights the way that even while we may be autonomous, we are also deeply dependent on others for affirmation and value. Bill C-7 declares that an entire class of people, those with physical disabilities, are potentially appropriate for suicide, that their lives are potentially not worth living. Indeed, were it not for their disability, we would not be willing to end them. I cannot imagine a more degrading and discriminatory message for our society to communicate to our fellow citizens living with disabilities. Now, reasonable people may disagree over the ethics of euthanasia, yet given the concerns raised here, it is understandable and eminently reasonable that many physicians and nurses object to participate in the provision of euthanasia in general and to those with disabilities in particular. Contrary to the claims of some, objecting to euthanasia is not motivated by selfish concern for personal moral sensibilities, but rather by a profound moral concern to uphold the value of the patient and to maintain high quality medical care. Moreover, the Canadian experience has shown that protecting conscience presents no obstruction to patient access. Bill C-7 should be modified to clearly ensure that Canadians' fundamental freedoms of conscience are upheld and supported in ways that Bill C-14 failed to accomplish. Finally, I implore you to ensure that the law requires, if this law is passed, that it requires the physical, social, psychological, existential, and spiritual needs of patients like Nathan have been thoroughly and systematically addressed before they are considered to be eligible for euthanasia. He and others like him deserve the very best opportunity for living before they conclude that their existence is pointless and should be ended. Thank you for your consideration.
Thank you very much for that, Dr. Gallagher. We'll now move on to the Council for Canadians with Disabilities, who have asked for an extra amount of time, and given my discretion, I've allowed them 7.5 minutes between the two witnesses that are appearing. Ms. Jantz will be making her opening statement through an audio file to be played. It'll be text to speech, and so she will be taking 6.5 minutes. So go ahead, Ms. Jantz. Thank you very much.
Chair. It's Dr. Jantz, please.
Dr. Jantz, my apologies. Go ahead, Dr. Jantz.
Justice Committee, I appear before you as the chair of the Ending of Life Ethics Committee of the Council of Canadians with Disabilities, a national organization with a mandate to preserve and promote the human rights of people with disabilities. I feel compelled to spend a few precious moments of my allotted time to register my concern, indeed, my alarm, at the breakneck speed at which this committee is operating. This committee has been convened to study the potential impacts of expanding eligibility for medical aid in dying to include ill and disabled people who are not dying. Those in charge of this committee are very aggressively rushing the important and complex work of the committee. All of this is happening in the middle of a global pandemic, when our focus as a country has been on taking measures to protect the lives of our most vulnerable citizens. At best, this is extremely ironic. At worst, it is hypocritical, irresponsible, and extremely unethical. As someone who relies on assistive and augmentative communication, I had to request additional time beyond the 2.5 minutes allotted for my testimony. This incident illustrates the reality of systemic ableism. Within a society designed by and for typically functioning people, ableism causes the support needs of people with disabilities to be viewed as excessive and unsustainable. This has enormous and very dangerous implications for the expansion of M.A.I.D. Disability scholar, Veronica Schwiena-Erd, defines ableism as ideas, practices, institutions and social relations that presume able-bodiedness, and by so doing, construct persons with disabilities as marginalized, and largely invisible others. Like racism and sexism, ableism classifies entire groups of people as less than, and perpetuates harmful stereotypes, misconceptions, and generalizations about people with disabilities. Unlike racism or sexism, however, ableism remains, in the words of Canadian disability scholar, Gregor Wolbring, one of the most societally entrenched and accepted isms. People with disabilities are at a higher risk of suicide due to systemic and internalized ableism. Yet they face substantial barriers when trying to access suicide prevention services. Medical professionals overlook typical sources of stress, problems arising from relationship breakdowns, depression, and isolation are wrongly attributed to disability. The removal of reasonably foreseeable natural death as a limiting eligibility criterion for the provision of M.A.I.D will result in people with disabilities seeking M.A.I.D as an ultimate capitulation to a lifetime of ableist oppression. In a truly just and progressive society, suicide prevention measures should be applied equally to all people. More and more Canadians with disabilities find themselves in extreme financial distress as the pandemic drives up costs while already meager provincial income support remains stagnant. What's more, some provinces have recently been publicly musing about reducing, or altogether scrapping, their income support programs for people with disabilities. Recent news reports indicate that some people with disabilities living in poverty are being driven to end their lives through M.A.I.D, because they lack the means to survive. Physicians report that patients with disabilities are requesting M.A.I.D upon learning that the wait time for accessible housing with the supports they require is 10 years or more. Given the demonstrated ongoing prevalence of ableism in Canada, the Council of Canadians with Disabilities is recommending the following amendments to Bill C-7 in hopes of limiting the bill's capacity to weaponize ableism in this country. 1. Receipt of adequate housing, income support, palliative care and home-based services should be prerequisite eligibility requirements for M.A.I.D. The onus for providing these supports at the level required must fall on governments. A person with disabilities should never bear the burden of trying to lobby for adequate supports. 2. Refer to the Supreme Court of Canada, by way of constitutional reference, Bill C-14's existing protections limiting M.A.I.D to cases where a person's natural death is reasonably foreseeable. 3. Any changes to Canada's M.A.I.D law must meaningfully respond to last year's end of mission statement of the United Nations Special Rapporteur on the Rights of Persons with Disabilities, wherein Ms. Catalina Devandes Aguilar communicated her serious concerns about significant shortcomings in the way all levels of Canadian government respect, protect and fulfill the rights of persons with disabilities. Specifically, she noted that there was a lack of protocol to demonstrate that persons with disabilities have been provided with viable alternatives when eligible for assistive dying, and that she had received worrisome claims about persons with disabilities in institutions being pressured to seek medical assistance in dying, and practitioners not formally reporting cases involving persons with disabilities. 4. Canada's amended medical assistance in dying law should follow the judicial directive of the SCC in Carter, which required a carefully designed system that imposes stringent limits that are scrupulously monitored and enforced. 5. Remove Bill C-7's provision allowing a disabled person's healthcare or personal care provider to be an eligible witness to that person's request for M.A.I.D. 6. Retain Bill C-14's mandatory 10-day waiting period requirement, as it currently stands, and the requirement for independent verification of all M.A.I.D requests by 2 witnesses. 7. In response to the prevalence of medical ableism, add language to Bill C-7 that will ensure that all discussions surrounding M.A.I.D are patient-led and not prematurely initiated by the physician. 8. Remove Bill C-7's provisions waiving Bill C-14's important and necessary final consent requirements. Bill C-7 will enshrine a lethal form of ableism into Canadian law by making medical assistance in dying a legally sanctioned substitute for the provision of community-based supports to assist people with disabilities to live. The Council of Canadians with Disabilities, along with the entire disability rights community in Canada, is therefore pleading with policymakers to rethink and revise Bill C-7 in light of the reality of systemic ableism. You must ensure that M.A.I.D does not weaponize systemic ableism in Canada.
Thank you.
Thank you.
Thank you, Dr. Jans. We'll now go for the remainder 1 minute to Taylor Hayat. Please go ahead for your 1 minute.
One domain where we're particularly concerned ableism will appear is in the medical system. I'd like to give you an example of what that looks like. Nearly 3 years ago, in January 2018, I became ill with a bad flu. I went to a walk-in clinic and was sent home with the usual advice: rest, Advil, and chicken soup. Contrary to what I was told to expect, my condition worsened and I began to struggle to breathe a few days later. I called the Ontario telehealth line and was advised to go to the ER. I called a few friends hoping to get a ride there, but no one could be with me until the next day. I took a cab to the hospital and was immediately admitted. A couple hours later, the doctor was no close to finding out what caused my illness. When she finally came to see me, she said, "The only thing we know is that this infection affects your breathing. You may need oxygen. Is that something you want?" My answer was, "Of course." She seemed surprised and unconvinced, so she asked again. My answer was unchanged.
Ms. Hayat, my apologies. I'm just going to stop you here and ask for consent of the committee because we are over the 7.5 minutes that's allowed in my discretion. So I turn to the members of the committee to allow Ms. Hayat to finish her testimony. I'll see a thumbs up, please. Mr. Zuberi? Okay, all right, I see everybody. Please go ahead, Ms. Hayat. Thank you.
My answer was unchanged. I said, "Of course." In that moment, I would have been able to refuse treatment and permitted to die, or in a moment of weakness, bought into the stereotype that my life wasn't worth living and requested and received a lethal injection. Breathing supports would be considered standard treatment for a non-disabled person in my situation, especially somebody in their mid-20s as I was. That's supposed to be the prime of your life. All the doctor seemed to see, though, was a disabled woman, alone, sick, tired, and probably tired of living. This is nothing new. A study by Carol Gill of the University of Illinois at Chicago shows that doctors often perceive disabled people's quality of life to be significantly worse than disabled people's own views. Whether disabled or not, Canadians look to these professionals as guides. Doctors have power to shape others'